Hi, and welcome to tonight's webinar on transitional issues, such as Medicaid, Social Security benefits, guardianships, and alternatives to guardianships. My name is Bailey Alpin, and I serve on the board of directors for the ARC of the New River Valley. If you would like to know more about our organization, please visit our website at www.thearcnrv.org. In general, during the presentation, pop your questions into the chat box, and we will also ask for questions at the end. So lots of time for questions tonight. Please don't hold back. And now for our main presentation on transitional issues affecting people with disabilities and their families. Anne Green has been an attorney for over 30 years and has received many accolades and honors during this time. Anne Green is a partner at the prestigious Anderson, Des Moines, and Green law firm, serving Roanoke, the NRV, and surrounding areas. It has been named one of the best elder law firms in the country year after year. So it is with much gratitude and appreciation that we thank you for taking the time to speak with us tonight, Anne. Welcome, and the floor is yours.
Thank you, Bailey. It's an honor to be here. I've known Bailey a long time, and she's a wonderful advocate in the New River Valley, and you are blessed to have her there. We've worked on a number of different things together, and it's an honor to be here. So what I'm going to do right now is probably share my screen, and you can see I have a PowerPoint on, and actually we developed this for attorneys to teach them about transitional issues. But let me see if I can start sharing my screen. So I can pull up my PowerPoint, and let's see, here we go. Okay. So I hope you can see it says transition planning for children with special needs. And that's what we're going to talk about tonight. And then tomorrow night, we're going to talk about special needs trusts and all that goes along with that. But as you know, as parents and advocates, there's a big step that occurs when someone turns 18. The law presumes that that person has authority and also has the capacity to make all their own decisions. And, you know, I'm a mother of 2 children. Thankfully, they're 29 and 27 now. But when they were 18, I would have liked to have been their guardian because 18-year-olds in general, I don't think make great decisions. I mean, maybe your experience has been different than mine, but their brains are still forming, right? They are immature in many ways. And so if we just look at the decisions they're making, and if you were participating last night with Lucy Bignell from the ARC of Northern Virginia, you heard her repeat time after time, making poor decisions is not the reason that we get people a guardianship. It's the incapacity to make those decisions. But so let's talk about the different issues that we're going to talk about tonight and tomorrow night. First of all, it's decision making. There's substitute decision making, which would include powers of attorney, medical directives, and then supported decision making, which I'm going to skip over pretty rapidly because Lucy talked about that last night. And then guardianship and conservatorship. They are substitute decision-making and supported decision-making are less restrictive alternatives. Guardianship requires guardian to court. And so that's a very restrictive alternative. Then we're going to talk about public benefits, Social Security, Medicaid, Medicaid waivers, Medicare, and other benefits. And then tomorrow night, we're going to talk about estate planning, which includes special needs trusts, a letter of intent, and ABLE accounts. Now, anytime you have a question, I ask you to put it in the chat, and Bailey's going to read it. And Bailey, feel free to interrupt me if it's appropriate, because sometimes wait until the end. If you have a question about guardianship when we've moved on to, Social Security disability benefits, it might be a little bit annoying. So just go ahead and interrupt me. I'd be glad to answer the questions. So
and real quick, I already see a question. Someone was asking if we're going to get this PowerPoint, and I can get that from you, Anne, and we can send it out to everyone's email that registered. So yes.
Okay.
Thank you.
Okay. So why is transition planning important? Okay. As I said earlier, at 18, a person is legally responsible for their affairs and the consequences of their actions when they're 18. So at 18, if you have a special needs child or a special needs loved one, that new legal capacity can be difficult to negotiate, meaning you take them to the doctor says, I'm going back with your child. You don't get to come back. You don't get to get the information automatically like you do as a parent of a minor child. You go to the bank and they have an account there. Now, hopefully you didn't set up an account just in their name and it's an UTMA account or a representative payee account, but you don't get to do things for them. So when my kids, for instance, when they turned 18 and they went off to, thankfully they went off to college. Not thankfully they went off, but thankfully they were able to go to college. I had them actually say they volunteered to sign, because I did not put any pressure on them to sign powers of attorney and medical directives. And why is that? Because I don't get to do that anymore. Yes, I raised them. Yes, we're paying for college, but no, I don't get to make those decisions. So I wanted to be able to pick up their prescriptions for them, find out from the doctor what's going on. I wanted to be able to access their money in their account if something had happened to them. Now, thankfully, I had to use those documents very little, but I can tell you if they were in a car accident or something, it would be really, really helpful to have those documents. So really, everybody at 18 needs to think about that, meaning everybody on this call. I'm assuming there are no minors watching this, although I'd be glad if they did. You need to think about, consider doing a power of attorney and medical directive, and if you own anything, a will, because otherwise the state of Virginia will decide that for you regarding a will. But for a power of attorney and medical directive, your family will have to go to court and become a guardian or conservator if you haven't named anybody to make those decisions. Often legal supports are needed to allow parents to make those decisions. Okay, and why it's important? Because we have to balance the child's capacity to make those decisions and what those tools are with the desires of that person. And we need to think ahead so that we can help them advocate for themselves and their wishes. So first of all, substitute decision-making. That means allow somebody to make a decision on your behalf. Now there's like when I gave a power of attorney to my husband and he gave one to me, I don't get to just run his stuff the way I want it to. And many of my elder clients are concerned about giving a power of attorney to a child, and sometimes with good reason, because the child acts like, well, I'm in control now. Well, that's not how a power of attorney works. A power of attorney works at the request of the person, gives them authority on behalf of the person, but they shouldn't be doing anything that the person doesn't want them to do. So a power of attorney is generally used for financial things. It could also be used for a medical power of attorney. There's an educational power of attorney, and that would be used primarily in school. An advanced directive could have advanced directions regarding what they would want to do if they were terminal. I often don't do that, depending on the capacity of somebody who I'm doing a medical directive, a medical power of attorney for. I often feel like they're very capable of deciding, oh yeah, I'd like this person to make my decisions for me if I were incapacitated. But when I'm starting to think, well, if you were this and this, it requires a different level of thinking, and I'm not always sure that that is appropriate. Now, I've had clients who have been in end-of-life situations with grandparents or even parents who know exactly what I'm talking about, and I feel very comfortable doing advanced directives for them. And then there's a psychiatric advanced directive, which would require a doctor saying, yes, even if this person objects, it would be wise to allow the parent to either medicate them or involuntarily commit them. And sometimes people agree with the person giving the power of attorney would agree with that. I haven't found many people willing to do that, frankly. And then a substitute decision maker would be a representative payee. Many times people don't need a guardian or necessarily a conservator because they don't own anything, but they need somebody to manage their money because they're really not able to do that. So substitute decision making is an alternative for the person making all their own decisions. Now, all those the variety of legal tools are ones that we talked about, but they rely on the principle, meaning the person signing the power of attorney, giving someone authority for that. They have to have capacity to do that, right? Like I have people coming in all the time that have an elderly parent, let's say, who's in maybe the last stages of dementia. And they're like, okay, I need a power of attorney. And I said, well, would your mother understand this? Can you get a doctor to tell me? No, she's way gone. She doesn't even know me anymore. Guess what? It's too late to do a power of attorney. It's too late. Why? Because the person doesn't have the capacity to understand what they're signing. So you can't get them to sign something that they don't understand. And so one of the issues when a child turns 18 is, what do they understand? You know, how now it doesn't mean they have to understand it the way I do. I can tell you, none of my clients understand the powers of attorney that they sign like I do, right? Why would they? They're not an attorney. So it doesn't require that level of understanding, but it does require the understanding of, I'm giving someone authority to do things for me. And it can be explained in a simple way. It can be explained and it can be a simple document, because often these folks don't own a lot of things. And the idea is, I have a legal responsibility to carry out the wishes of the person I'm acting on behalf of. I don't get to do what I think I need to do. Okay, so power of attorney. There's a Uniform Power of Attorney Act, and there's all these bells and whistles. It's generally, sorry about that. It's generally for financial matters, contracting, working with the government. It could be for Medicaid, but the person has to have capacity to do that. And also, and this is very important to know, that the principal doesn't give their authority away. So if I give a power of attorney to my husband, Barry, right, doesn't mean that I can't go to the bank and withdraw my money or do what I want with it. It's still my money, right? Barry has the opportunity to use that power of attorney to do things that we've decided to do, that maybe I'm working all day and I can't get to the bank during banking hours, and he's going to do something for me. He can write checks on, I mean, all of our stuff is joint, so that's kind of irrelevant. But for my 401k or my IRA, which is only in my name, he could use a power of attorney to get at that, to make decisions regarding investments and things. But I always retain my own right to make those decisions. And so this is just the definition of incapacity. So sometimes when we're doing a power of attorney, we might do a father and a mother, either of whom could act for the person. I generally don't do them as a joint power because I find them very difficult to make agencies use them or acknowledge them, a bank, for instance. They would, if one of my clients has signed a power of attorney and then later on there's a guardian or conservator in place, the power of attorney, unless the judge revoked it, is still good. So I'm not going to go over gifting because most of our clients don't need to have gifts done. And educational power of attorney can be done from the Virginia Department of Education has a handbook, and they even have an educational power of attorney in that. So you could go there and get that. And again, this would be a power of attorney, but just for educational purposes. I don't find them particularly helpful because the student still has authority, and it just allows someone to make decisions on their behalf. But some people use them and they have liked them, but they can be just like the power of attorney. They can be revoked at any time. The principal, the person who signed this document, retains authority to revoke them or get rid of them. And here's a educational power of attorney. This is an example of one. An advance directive. Now, advance directive has two parts. One is a medical power of attorney, which I think is the most important part for us and for anybody. And that would name somebody to make some decisions on behalf of the person if that person couldn't make them. Powers of attorney for financial things are generally good on their face. I don't have to be disabled to do that. I don't have to have the inability to make my decisions. I name somebody, they have that document, it's good, they can take it to the bank that day. The advance directive requires that I am not able to make those decisions, because let's say the doctor comes to me and says, your husband says we're going to take out your spleen. And I'm like, no, I don't want my spleen taken out. Well, I get to decide, right? He only decides if I'm incapacitated, if I'm passed out, if I'm under anesthesia, and they have to decide whether they're going to do something else that they hadn't gotten my approval for before I was put under anesthesia. the advanced directive, as well as the powers of attorney, could be registered with the Advanced Healthcare Directive Registry in Virginia. If you want to do that, it's a free service from the state of Virginia. Now, the other part of the directive is end of life care. And as I told you earlier, I often don't do them with my clients with special needs unless I'm very clear that they can understand doing that. I certainly think they can understand having someone make their healthcare decisions for them. And some of them do have very clear wishes regarding end of life care. And if so, we'll write them down. And again, you have to have capacity to do that. And there's a statutory form, and that's where it is. Now, the Psychiatric Advanced Directive is basically using the medical directive in the statute, but adding other provisions. And generally, this is for someone who has a mental illness. So I'm not going to go over much about that, but here's the language of it. To authorize my admission to a healthcare facility for the treatment of mental illness for no more than 10 days, even over my protest, which obviously you can't do. Otherwise, you'd have to go through an involuntary commitment hearing, and there'd be the doctor or whoever says that you really need to be committed. But this would allow your agent to actually take you to the hospital and say they're off their meds. You know, this often happens with somebody with bipolar or schizophrenia who just stops their meds. And once they're on their meds, they're okay. But until then, they've lost their ability to make their own decisions. And so this allows somebody, if I have bipolar or I have schizophrenia, I can name somebody who said, even over my protest, take me to the hospital. And if they will admit me, you can do that for 10 days. It can be very powerful, but again, I told you, I don't know many people who've actually done them. A representative payee is somebody who, and many times for our situation, it will be for SSI purposes. Somebody will become the payee for somebody who they've determined cannot make their own their own financial decisions. And they have a duty to account to the Social Security Administration, except if you're a parent, they're not requiring you to fill out the forms anymore, but you still have a duty to use it for that person's benefit. And I would keep written records and written accounting. All right. Okay, so now, supported decision-making. I'm just going to say a few things about that because Lucy went over that last night, and I don't want to take up all our time doing something that she did so well last evening. But the idea of it is that all of us, and Lucy made this point really well last night, that all of us use supported decision-making, which means, you know, I can't be good at everything. You know, if I were hit by a truck and I needed a personal injury attorney, I'm an attorney. I should be able to do that. No, I know nothing about that. I would hire an attorney to do that. I get support for my decision. I talk to them. Should I do this? What should I do? All of us do that. I don't know. I'm a terrible decorator. My husband will tell you that. He's so good at that. I'm terrible at it, you know. So we have this woman who comes by, and she is awesome. She's artistically gifted. I'm artistically challenged. And she comes and looks at her house and say, well, move this here, move this here. She's awesome. So all of us use it, supported decision-making. You know, if I made all the decisions regarding our house and our decorations, it would be a mess, right? Many people don't know much about investing. Supported decision-making would be like, okay, you hire a good financial guy. So it's, whoa, so sorry about that. So supported decision-making is a way to help someone. And the big thing about this is they have to have the capacity to make their own decisions, right? To help someone, inform them, educate them, support them, encourage them to make their own decisions. And these are some of the ways that you could do that. And Lucy went over some of these. Use of visuals, you know, show this picture, show this, you know, and I'll show, I have another PowerPoint where we talk about end of life care and what that would look like. You allow time for decisions, you know. Sometimes people need time to process. Pros and cons list. Okay, what's the benefits of this? I have to have a surgery, you know. I'm afraid of going to the hospital, or because then I won't be in so much pain, so you make a pro and con list. Let's talk about that, rather than just say, oh, the doctor said you should do it, just do it, right? Role play, talk about those things so they can kind of get it in. It's like using all the different methods, the vision and hearing and touching and feeling, ways to communicate. We all have different learning styles, and it's a way to encompass those different learning styles to help somebody make a decision. And then you can also include somebody in your appointments. I want my mom here, or I want my dad here at my doctor's appointment. I want somebody else at my IEP meeting, just to help support that decision, not to make their decisions for them, but to support the decisions that they want to make. Okay. And it supports autonomy, independence, community integration. Now, Virginia has passed a supported decision-making legislation, and they're going to be trying to figure out forms and ways to do that. There hasn't been anything approved in Virginia right now, but there are some formal agreements that people can do for. We haven't codified anything. And these are some examples from other states, Delaware, and I forget what that one's from, but anyway, there's other states. And this is the law that was passed, that we have to have it. So now let's get to guardianship and conservatorship. And I do a lot of guardianship and conservatorship, but we have to always remember that the law requires that we have the least restrictive alternative, which means we got to look at, can they sign a power of attorney? Can we work with substituted decision-making, even if we have a power of attorney to do that? Or are they really unable to understand the nature and consequences of the decisions that they're making? I find it pretty easy to get the doctors to tell us what we want if we want to get a guardianship. I don't know that that's good or bad. But supported decision-making, as Lucy pointed out last night, can also be used in a guardianship. So even if you have guardianship, you get to make your medical decisions for your child, or educational decisions or residential decisions. Supported decision-making could help them understand the decisions that you ultimately get to make, but to get their realistic input. I see too many people. I work with, I teach a Sunday school class for folks with intellectual disabilities. And my co-teachers are wonderful, but I've had people, volunteers, who come and they feel sorry for the folks. They love them. Clearly they love the class, but they really don't respect them. They really don't respect them. And that is really important, right? I mean, and I've had people say to me at church, oh, it's such a shame. I just wish they could be normal. I just wish they could be. And I said, I see it very differently. They have special qualities, and they have unique abilities, and we don't, my son said this, and I'll share this with you. We do a retreat for a group in Lynchburg every year at the Virginia Baptist Center called Eagle Eyrie, and they do a special needs retreat every year. And it's been canceled the last 2 years because of COVID, but it's usually the third weekend of October every year. And my kids have done it every year of their lives, except for the last 2 years. And I've done it for the last 32 years, except for the last 2 years. But because my children have had the experience of doing that, my son said to me, and he was like 12, he says this, he says, Mom, when I thought about going to heaven, I looked at all these people, and when we got to heaven, they would be more like me. They would be whole and healed and everything. And after being in worship with them, after spending years with them, he said to me, no, Mom, I think maybe when we get to heaven, we'll be more like them. And I really think, because that's a level of respect and of appreciation for who they are. And so I think, so before we go forward with a guardianship or conservatorship, we want to make sure that really the person is not able to make those decisions on their own. And there are plenty of people who are not able, who would be taken advantage of if their parents weren't around. And that's something to consider. So Now, a conservator and a guardian can be appointed at age 17 and a half if you're the parent, or I think the grandparent of, typically you'd wait till 18, right? Because they don't have legal authority to make their decisions until they're 18. And this, again, is the most restrictive decision-making tool. And it could mean, and does mean, loss of rights. And it does not necessarily terminate a power of attorney. Let me put this up. Hold on. There we go. Nope, whoops, sorry. All right, so the guardianship requirement is that they're incapable of receiving and evaluating information effectively or responding to people or environments to such an extent that the individual lacks the capacity to meet the requirements for his health, care, safety, and therapeutic needs without the assistance or protection of a guardian, or in the case of a conservator, to manage the property or financial affairs or provide for his support or for the support of legal dependents without the assistance of a conservator. And again, poor judgment alone does not mean that you can get a guardianship or a conservatorship. Okay, let's see. And the Uniform Adult, we call it UGETCHA, Uniform Adult Guardianship and Protective Proceedings Act. If some child was between maybe parents in different states, it would say a priority system where you could get jurisdiction. We don't have to go through that. But these are important. Guardianship are governed by Virginia law. And what happens is generally that you come in to the office, we get information regarding the family, the person, what they can do, what they can't do, what type of guardianship we need. Do we need to make all decisions or just some decisions for this person? We also need a doctor's report. We need medical information that yes, in fact, that person is incapacitated. So these are the issues in guardianship that they would address. One would be support, care, health, safety, where they live, what's education decisions, therapeutic treatment, and their residence. Now, one thing you have to remember, and that's why to me, it's important that you get somebody who knows guardianships. I would ask, if you go to an attorney, how many guardianships have they done, and under what circumstances? Because I'm hoping that this is not true anymore, but many of the judges did not know when they put in what I would call a plenary guardianship, a guardianship for everything, that the person loses their right to vote and to make medical decisions and sign contracts, which is typically what you'd want, to sign leases, to sign a power of attorney, to do advance directive. But they also lose their right to drive, to own a gun, to make a will, sign a power of attorney. All of that are rights that they could lose unless they're specifically retained, right? Or if it's a limited guardianship for specific purposes. So a guardianship is not a guardianship. It needs to be tailored to the person's needs. All right, so types of guardianships here, it's just a private guardianship. That's mostly what we're talking about. Parents becoming guardians. There could be a public guardianship, and that could be, there's public guardianships throughout the state. Right now, they're completely full. So we're hoping that in this legislature coming up in January, February in the state of Virginia, they will allocate more money for that. We're hoping, because they're all filled up. And then there's a limited guardian, which would be for certain things. Now, a conservator is different than a guardian. That's for financial things. Depending on the child, there may not be any money other than their SSI. And if so, you wouldn't need to be a conservator. A conservator manages someone's money. Sometimes that comes if a grandparent or somebody leaves money to somebody. It also could be if they became incapacitated later in life, have a head injury, or they have mental illness, which doesn't really rear its ugly head until late 20s or 30s, which often happens. They may have assets that they can't manage anymore. And so that would be, we'd go to court to become a conservator. So let me go back a minute. So when somebody wants to consider guardianship, we of course talk about alternatives. What would the alternatives be? And that would be the power of attorney, that would be supported decision-making. And then finally, if we feel like none of that would work, we would do a guardianship and conservatorship if necessary. So I gather the information, we get the medical documentation, I file the forms at the court, and then a guardian ad litem, an attorney appointed to represent the best interests of that person, is named. And that person will serve papers because there'll be a hearing set, and then notices go out to family members because they want people to know about this. I'm sure you've seen We Care a Lot, you know, that awful movie about guardianships. And that might be true in Nevada or California or whatever, but here people get notice of it. You don't have a guardianship or conservatorship put in place without getting notice of it. I mean, it just doesn't happen. So family members need to be noticed, people who know you, that kind of thing. And then that person gets served papers that say, warning, this is a hearing where you may lose certain important rights. And it's scary. It's a warning to you. And that you have the right to your own attorney. You have a right to a jury trial. I've never done a jury trial, but you could ask for one. You have the right to present your own witnesses. All those things come up in a guardianship. The guardian ad litem typically will serve the papers, or the sheriff or somebody can do it. I typically never use the sheriff because I think it's scary and I don't think it's helpful. But people can, and they do, or a private process server could do it. I like using the guardian ad litem so you can go over the documents and make sure that they have gone over all, and they have statutory things they have to do. And so they have to go over all that. And then we have the hearing. The guardian ad litem has to write up a report. Hopefully they've talked to the proposed guardians and conservators. They've talked to the person. They maybe have talked to the other witnesses. They've reviewed an IEP that's required. They have to talk about substituted decision-making now in their report, saying this is why it would work or why it wouldn't work. I mean, I've been a guardian ad litem one time and I said, I can't support this. I think this woman is 18 and she's making 18-year-old decisions. And so what happened was they filed a guardianship for a woman who was 18, and I was appointed guardian ad litem. I met with her and I said, you know, do you know why we're here? And I served the papers on her. And I said, do you know what a power of attorney is? And she's 18. And she said, no, I don't really. And I explained it to her. And I said, if you were naming someone as your financial power of attorney, who would that be? And she named the people who they named in the petition. And I said, well, how about for medical decisions? What would you think? And I said, would it be the same people? And she said, no, it would be my grandmother because she's a nurse and she's really good at those decisions. Exactly who they put in it. And so I'm thinking, why are we here? And so I went back to the family and I said, I'm sure she has some deficits. She has Asperger's. And I'm sure she has some deficits, but tell me why are you going to court at 18 before she's really had any chance to make any decisions on her own? And this is about 15 years ago, before we had substituted decision-making, before we had a lot of these other things. And they said basically because she was graduating high school and they wanted her to go to the Wilson Center for some vocational training. And she didn't want to go. And I said, okay, why didn't she want to go? She had a boyfriend and she didn't want to leave her boyfriend for a year because the program at that point was for a year. And I'm thinking, okay, maybe that wasn't the wisest decision, but I'm telling you that that's a typical decision that an 18-year-old would make, right? You choose your boyfriend over your education. I mean, it's not a wise thing, but it didn't show that she was incapacitated to make her decisions. And so I said, I can't support this petition. And I said, I think she needs to do a power of attorney and a medical directive. And I told her, I said, look, your family loves you. They're trying to help you. And if you don't work with them, unfortunately, I really think if it had been another guardian ad litem, she would have had a guardian. And I think that's wrong. I think that's wrong. I don't think that should have happened. And I said, I can tell you next time when they file, they're not going to ask me to be guardian ad litem because they'll find somebody who will just rubber stamp it. And unfortunately, that can happen. I think it happens a lot less now because guardian ad litems have to go through training, and they have to, and there's a lot more information out there about supported decision making, or not taking people's, making sure it's the least restrictive alternative. So anyway, now we're back to conservatorship. It's the same process as guardian, but only if the person has money outside of Social Security disability. Okay, now, all right, so now let's talk about public benefits. So before we go on, Bailey, are there any other, is there any other questions on guardianship and conservatorship?
No questions. I see Jonna made a comment that guardianship is expensive for families. How expensive is a power of attorney? Thank you, Jonna.
Oh, that's I mean, at the most, a couple $100. I mean, it's much less expensive. And thank you for bringing that up. Yeah, it is expensive. You know, it's expensive because you have to hire an attorney, and they have to spend hours drafting the petition and going to court and getting drafting a decree. I mean, there's a lot of hours. I mean, I'd say a minimum of my time would be 6 to 7 hours on every guardianship I do. And that's a lot of time, and it's expensive. And probably attorneys who don't do it as much probably even spend more time. You know, so yes, and thank you for that question. That makes a lot of sense. And that's another reason you'd want to maybe not do a guardianship as a knee-jerk reaction. Bailey, any other questions?
Jonna asked a follow-up question. She's asked, how about payee? Is that less expensive?
So payee, that's not something you can do. That's something that let's just talk about Social Security, that the Social Security Administration makes that decision. So what would happen is you would make probably take the medical information you have about your child and say, you know, they really can't make their decisions. And Social Security will make that decision. They'll decide, okay, we think that's right. We'll make you representative payee. And so it's really just a process at the Social Security Administration. It doesn't cost anything to do that. It looks like there's some more chat questions. Anything else?
Yeah. Mareko, I'm sorry if I'm messing your name. Can you unpack 3 different guardianship setups more in details?
Okay, 3.
So was there that limited guardianship, the public guardianship, and the private guardianship? Is that what you're talking about?
Okay, I'm sorry. Private guardianship, I think the labels are probably misleading. It just means that it's in a private person who is named the guardian. They're the same proceeding. All of them are the same proceeding. A public guardianship is naming a public agency that's, you know, usually a nonprofit organization that is named as a public guardian. And I forget what was the third one.
Limited guardianship. Oh, there it is. There's the slide.
Yeah, I just brought it back. The limited guardianship, and that is just for specific things, but you'd name somebody to make that decision, whether it's a public guardian or a private guardian. Usually for limited guardian, it's typically in person. It's not a public guardian, although I guess it could be. So a limited guardian, I'm trying to think of one that I have done. It may be that someone can't make their medical decisions. Okay, so I had a case one time when this poor woman, she every time she got her period, she was afraid that she was dying, and so she would run out of her group home, and she would leave and try to run to the hospital, or she'd call 911 because she just couldn't get it that she wasn't dying, that it was a natural process. And so actually that's a case where we had a guardian in place, and then we actually got the approval from the judge to have her sterilized. And that's one thing you all need to know, that just because you're a guardian of someone, you don't get to decide whether they get to have children or not. You don't get to sterilize them. I've had clients come in and say, okay, I'm going to become the guardian and we need to have her have a hysterectomy. And it's like, no, that's another level of of rights that you lose, and you have to have a good documentation about why that was necessary. And in this case, the case I was just referring to, it was really, really, the girl, first of all, the woman wanted it. She wanted to stop bleeding. She didn't want children. She just wanted that to stop. It scared her to death. Okay. And so we had evidence that she understood what was going to happen for her to have a hysterectomy, and evidence that medically, I mean, it was really destroying her. Her mental health was declining. It was really, every time she got her period, it was just a decline in her functioning ability in all different areas. And so not only did she want it, but the doctor thought it was best. And they had tried doing patches and, the birth control pill and a bunch of other things, but none of that was, and those are the things, if you want to get someone sterilized, you have to do all of those things. You have to say that none of these work, because unfortunately 100 years ago, maybe not even 100 years ago, but our history is replete with people who were sterilized against their will because they had some kind of challenges, and that's just wrong. And so now we've gone to the, and it's not the other extreme. We've taken some precautions to make sure that that doesn't happen to people who should have the reproductive rights that all of us should have. So anyway, any other questions there, Bailey? I see some more.
I think that's all I can see.
Okay. Okay. So, all right. So now public benefits. I'm going to start with Social Security. Okay. So first of all, I want you to think about when your child turns 18, and I don't know if some of you may have applied for SSI before they were 18. And if you did, you'll find out that the Social Security Administration wants all your information about how much money you are bringing into the household, because your child is a dependent, and therefore they rely on your income. And so, but at 18, that changes. Okay, they become their own person. So it's the assets that they have. And I hope that you don't keep money in your child's account, and maybe they don't even have an account, but certainly not more than $2,000. And so the Social Security Administration will look at them as an individual at 18 and find out whether they could work or not. Now, the needs-based benefits, when we're talking about that, we're talking about, first of all, SSI, which is, again, you have to have a disability, and you have to have limited resources and limited income. Okay. And when in this chart, there's entitlement benefits and needs-based benefits. At 18, your child probably doesn't have entitlement benefits because he didn't work. They probably didn't, well, they couldn't have worked that long. So they would be looking at SSI. And you have to determine that they are unable to work to get SSI. Medicaid, and we'll talk about SNAP and housing benefits, they're all needs-based. Then there's entitlement, meaning you get these not because you have low income or low resources, because you worked. And Title II benefits are children disability benefits, and generally that's because of their parents' work history. And if they were determined to be disabled before they were 22, they will be linked up with their parents' Social Security benefits, which is good because they'll get more generally than they would on SSI. And there's a little more flexibility with that. They're able to, like, if you work and you're on SSI, you'll lose almost $2. You'll lose $1 for every $2 you earn. For entitlement benefits, if you're drawing Social Security because of your parents' work history, that doesn't happen until you earn a lot of money, and $1,200 or $1,300 a month. And then you could lose the whole benefit, but it won't be $2 for one. It's either you get it all or nothing. And then Medicare comes along and you get childhood disability benefits. 2 years after that, you'll get Medicare. And then, of course, we all know about IEPs and publicly financed education. That's an entitlement. You're entitled to that. You don't have to have low income or low resources to get that. So let's talk about Title 16, Title II of Social Security benefits. Okay, so this is SSI is a benefit. that for people who are disabled and have limited income, and it's intended to pay for food and shelter. Guess what? They're working on taking out food. So it could just be used for shelter, which would be so great. And so at 18, I would urge you, if you have a disabled child, to apply for SSI. And the reason is you get linked, they get the disability determination that they were disabled under age 22. They'll get linked up with your benefits, and they'll get a payment, 700, and right now I think it's $83 a month. And it's not a lot of money, but it is some money. And in order to get the full benefit, and this isn't in the outline, but I want to mention it to you. So when parents, if you go and apply for Social Security, they're going to ask you, are you going to charge your child rent? And most of my parents, if they haven't been coached, say, no, I'm not going to charge them rent. They're my child, and they can't work. So no. Well, guess what? If you do that, that's called in-kind support and maintenance. You're giving them food and you're giving them shelter. So they'll lose a third of their check. They'll get $400 and something or $500 or something a month instead of $783 a month. So how do you decide what to charge them? What you do is you add up all of your housing costs, and that would be your mortgage, your insurance, your taxes, your utilities. And if you look on the SSI website, they can tell you all those 10 things. You add them all up and you divide by the number of people who live in your home. So if there's 5 people living in your home and all those cost $2,500, then each person should be contributing $500. And if you say, well, I'm going to charge my child their fair share of the living expenses we have, $500, then the rest of their money is going to be used for their food. And as long as you do that, so what the food and shelter costs equal or less than their $783, you won't lose a third. Now, the bad thing is that people who have a very high mortgage and very few people living in their house, they can't meet that. So you could try doing a rental agreement. I haven't had as much success with that. But in our area, thankfully, often they can pay their fair share of the expenses. It's not technically rent. It's just they're living in the house. They're over 18. They pay their fair share, and that's what you're going to use the money for. All right. So SSI, you have to be disabled, limited income, limited resources. And this is what's important. The inability to do any substantial gainful activity because of a medically determinable physical or mental impairment, which can be expected to result in death, which is not the case that we're talking about, but can be expected to last more than 12 months. And so many of our children will meet that criteria, and some of them won't. So so it's $793, sorry. So $793 is the monthly benefit. And that's unearned income, earned income, meaning if they're working, and then in-kind support and maintenance. So that reduces it up to $281. So right now it's $281 a month. Even if you're providing $500 a month for your child, or let's say it's $1,000 a month, you've got a huge mortgage, lots of utilities, and there's only 3 of you living there. And if he was paying his fair share, it would be $1,000 a month. Well, they're only going to reduce it by $281. So he's not going to not get any of his SSI. But the point of it is SSI is for food and shelter. And if he's getting food and shelter from someplace, then he doesn't need the full SSI amount. And again, I'm hoping that they're going to be taking, I'd say in the next year, it's very likely that they're going to remove food. About 15, maybe 20 years ago, I can't remember now, but it's been a long time. They used to have it food, shelter, and clothing. Well, now they took out clothing, right? They take out food. It's great. So that people who buy your child dinner, if you provide somebody who's living on their own food, it's not going to affect their SSI payment. I think that'd be awesome.
And I have a question.
Yeah.
Is this a good time?
Yes, fine.
Okay. This is kind of long, so and there's a couple things here. So one of the most frustrating issues parents face is when their school-age children through age 21 learn employment skills through a paid supported employment as part of their public school programs. These jobs usually pay minimum wage and are under 10 hours per week, but part of these wages are sometimes subtracted from their SSI or SSA benefits. There used to be an exclusion clause for students, so wages were not garnished for students, but that appears to have gone away. Do you know what happened with this exclusion clause? What is the current SSA policy regarding student earned income?
Okay, I think there are programs that if it's typed into Social Security in that way, and I would work with DARS on that, that they should be able to help you with that, because yeah, my understanding was that it was exempt because it was a school-based program, and that they were not. Now you still have to keep it under 2,000, right? Because then you could lose Medicaid, you'd lose your SSI, but that income did not affect their SSI payments. So I'm sorry, I don't know the answer to that. So I would check with the Department of Rehabilitative Services, and later on in the presentation, I'm going to talk about the Ticket to Work program and some other programs, because there's ways. Like I had one client came in to me, and he was actually from the New River Valley, and he came in very intelligent, but was very physically disabled, and he was making $75,000 a year still on Medicaid. Now he wasn't getting SSI, obviously, but he was getting Medicaid because he had so many accommodations and had so many medical expenses that he was able to keep it. And there's certain programs that, if like Medicaid Works and things like that, that can allow you to do that. And I there should be a program like that. And I would encourage you also to check with the special ed person at school. I mean, that seems to be something that they should know about. And I'm sorry, I don't know, because my understanding was that it was exempt. So
there's a follow-up here asking, once students with disabilities age out of public school, and if they work for pay, some of them are required to report their income monthly, and their benefits are garnished. Others are told they only have to report if they earn above a certain amount. No one has been able to explain the rules here. Who has to report monthly? Who has to stay under a monthly earnings amount before the benefits are impacted? Do you know the rules?
Okay. So if you're on SSI, if you're getting supplemental security income, 793 or whatever you're getting, you have to report your income, and you have to report it monthly. So now some people are getting Social Security child disability benefits, so they may or may not be getting SSI. As far as I understand, if you get SSI, you've got to report it monthly. If you're getting childhood disability benefits on a parent's work history or their own work history, right? I still think you have to, I don't think you, okay, I think you have to report it monthly, but it will not affect your benefits unless it's over the amount of substantial gainful employment, which I think now is about $1,300 a month. So it won't affect the benefits. I still think you have a reporting requirement. That's my understanding. If I'm wrong, correct me.
So the representative payee would be the one that needs to report that if they have one, or
the person should, but I certainly think if you're the representative payee and you know about it, you should. Yeah. Because they will lose their benefits. You know, I mean, they're going to lose at $2 for $1. They'll get $20 disregard, and yeah.
And then Lucy posted in the chat box, thank you, Lucy Cantrell, from the ARC of Virginia. She posted a link, and you can just click on it, and it takes you to, I guess, the Social Security Administration. And it looks like the spot student earn income. And I think that's what you're talking about, Jonna. So thank you, Lucy.
Yeah. Thank you very much.
Okay, we're all clear.
Since I can't see that, would you send it to me? Because I'd like to look at it.
Yeah, I'll copy it. I'll email it to you. All right, thanks, Ann.
Oh yeah, absolutely. We're always learning, you know. Now there are resources that are exempt. So if you're living in your own house, that's an exempt resource. your household stuff. They don't care about tangible personal property, meaning clothes and accessories. You can have one vehicle and items related to your disability, including you can have a vehicle and then you can have another like a mobility van or something, and then money for burial expenses. Pretty much everything else is countable. Now, Title II benefits. These are child disability benefits. A general rule is that a disabled child, and it can be, well, Title II benefits are from a parent, but you could also receive disability benefits on your own work history. So actually there's 3 types of Social Security that somebody possibly could get. They could get it from their parents, and let's say they only got a couple $100 because their parents didn't have much work history. And then they could get SSI to make some, but if they work enough, they could be drawing eventually on their own disability history and their own payments into Social Security. So you could potentially get 3 types of Social Security. And now child benefits are if a parent is disabled or retired. Generally, a child's disability benefit is going to be about a half of the parent's benefit. There's a maximum benefit per family, so it may depend on how many dependents that person had. The other is if the parent dies, the child's entitled to 3/4 of what the parent's benefit was. So, primary eligibility requirements is the insured status of the wage earner, the relationship of the child to the wage earner, the age of the child. So you have to have a disability determination before age 22. And that's important because I've had a lot of parents say, I don't need the SSI, I'm not going to do that. And so they wait till they're 30 or something. That doesn't mean that that child won't be able to link up with their Social Security benefits, but it's going to be harder. If you get that determination, at 18, then it'll be almost automatic. So,
and I got some questions. I'm sorry.
Yeah.
Are child disability benefits only after age 18?
Well, it depends. If the parent is disabled or retires, right, or dies, there are minor benefits regardless of disability status that children get.
Okay.
So yes, if you're just asking for a pure disability benefit, yeah.
And can one change from SSI to child disability benefits? If yes, when and how?
Oh yeah, of course. So if you're you get SSI, okay, and that's $793 a month, and then your parent retires, okay, and they're getting $1,200 a month, let's say, Social Security, and you're entitled to $600. So now $600 of your check will be childhood disability benefits, but you're entitled to $793, and so you actually get generally a little bit over $800. So you'll get childhood disability benefits and SSI. Yeah. And eventually, if your parent died then and you retire, you get 90%, you'll get $900 a month and you will get no Social Security. I mean, SSI, you'll get no SSI. You'll get all childhood disability benefits. Does that make sense?
Yes.
Any other?
I think that's it. Thank you, Ann.
So again, the disability requirement is 12 months. Okay. And then here, this is the question. If a child is eligible for both, you could apply for both. Okay. SSI beneficiaries are categorically eligible for Medicaid. They're just going to get it. Right. And then after you get CDB, which is childhood disability benefits, they're entitled to Medicare after 24 months. Okay, so I want to stop here because we have a very special guest. She is a parent and she's an incredible advocate. And I want her to tell you about HIP benefits. And this comes in because we were talking about, okay, when is she going to get, when is my child going to get Medicare? Because I'm going to lose some benefits if that happens. And so I'm going to let Kathy Cole, who again is a wonderful advocate for her child. And I want her to tell you about this benefit because I think it's a very unknown benefit. Kathy, can you?
Thank you. Can you hear me? Can you hear me?
I can hear you.
Kathy. Yes, thank you.
Okay, I'm sorry. The benefit I want to talk about is HIP, and it's HIPP. It stands for Health Insurance Premium Program. And I just stumbled upon this because there was a talk on it, but the subject was HIP for kids. And at that point, my daughter was no longer a kid, she was an adult. But I thought, well, I'll go listen to it and see if I can provide information for somebody else. Well, thankfully I did, because HIP is not just HIP for kids, it's plain HIP as well. So under age 19, it's HIP for kids. Over age 19, it's HIP for adults. And what that means is if you have a child or adult child who has Medicaid, and you are covered with a group health plan that includes that child who's on Medicaid. For example, my group health plan covers myself, my husband, and my daughter who is adult disabled and has Medicaid. There is an application process that you can go through, and if approved, your health insurance premium will be reimbursed. Whatever you pay for your health insurance through your employer is reimbursed to you. Now, there are some qualifications. Of course, your adult child must have Medicaid. You must be enrolled, of course, in a group health plan. And that medical plan has to be comprehensive, has to cover inpatient, outpatient services for physicians, prescription drugs, labs, x-rays, and that kind of thing. It does not have to include dental. It does not have to include vision. And dental and vision, if you pay for that separate, is not considered. And there are some stipulations. They look at the actual health insurance plan. And if your deductible is less than $1,400 per individual or $2,800 per family, then you are eligible. Another thing I just recently found out, though, is you can only have 3 family members on your health plan in order to be considered. And that would include your disabled adult child who's on Medicaid, and 2 that are not on Medicaid. If you have 4 people, then that 4th person must be a Medicaid recipient as well. So you're kind of limited to 3 if you only have 1 child or 1 person on your health plan that has Medicaid. As Ann said, I just discovered recently that once my daughter starts receiving SSDI, in 24 months, she's eligible for Medicare. And at that point, when she starts receiving Medicare, even if she has a Medicaid secondary, she no longer qualifies for HIP. So that's a little bit discouraging. You have to submit an application, and there is an employer verification part where they have your employer verify your premiums and the percentage of the premium that they pay. And then they look at that and they determine yes or no if you're eligible for the program. If you're eligible for the program, they will pay not only for the adult child who has Medicaid, not only for their portion of the premium, but the entire premium for the whole family, which is a great benefit because you're being reimbursed for your health insurance premium. And the way they determine how much they will pay, apparently they have a like a group average medical cost. And I thought it was probably the medical cost for my own child, what they would have to pay if, you know, all of her medical expenses were submitted to Medicaid, but it's not. It's some kind of calculation that they have. That is a calculation for the average medical cost for a Medicaid recipient. They also factor in the age of the Medicaid recipient who's on your plan, the region in which that person lives, and the gender of that person. And they put all that together and they come up with a cost. Now, my daughter's allowable reimbursement is $2,436.14, which is way above what I pay for my medical insurance per month. So they reimburse me the entire amount that I pay for my group health plan. So that is an excellent benefit for anybody who might qualify for that, who has group insurance through their employer. I would encourage them to fill out that application, see if they qualify, because that's money in your pocket and you're still getting that medical coverage and your child still has the Medicaid secondary. When you're on HIP, and I don't know if people know about or are familiar with the managed care organizations, you are exempt from having to have an MCO because I guess they consider the fact that your group insurance probably has some kind of MCO anyway, and they don't want to interfere and say you have to go to this group of physicians when it's going to then not, your group insurance won't pay for it if you do. So you're exempt from being a part of an MCO for Medicaid. If you're on COBRA, if you go on COBRA, that is considered as well. So you can apply for the benefit if you're on COBRA, and they will pay up to that amount that they determine is their maximum allowable amount. And the only other thing I had to add is, you know, once the person on Medicaid receives Medicare, they're no longer eligible, even if you've been approved for the program. If the parents receive Medicare, it doesn't matter. But if the Medicaid recipient receives Medicare, then there's no longer an eligibility requirement being met. And that's all I have, and I hope that helps somebody, because I wish I had known it a lot earlier.
Yeah. Thank you so much, Kathy. And again, where would they apply? Was that the Department of Social Services?
There is a website, and I think Bailey has the link to it.
Yeah, it's through the Department of Medical Assistance Services. And I put a link on the chat. I'm also going to follow up with, I downloaded their brochure, which has active links on it, so to the application. So I'll email that out with the follow-up stuff as well.
And Bailey, I will send you a link to, there's a program manual that DMAS has for HIP, and it gives a lot of good information about qualifications and, you know, what's covered and that kind of thing. So that would be helpful to look through as well.
I'll send that out too. Thank you so much, Kathy. Thank you so much for being here.
You're welcome.
Yeah.
Thank you.
Are there any questions in the chat, Bailey?
I don't see any. I think everyone just was, you know, probably the first time they've heard about this as well. They were really interested in links, and so we'll get that all out to everyone. But
Good.
You can proceed. Thank you.
You're welcome. So now we're on to Medicaid, which is, you know, the main medical benefit that many of our families need and desire. So it's a federally funded program, but it's administered by the states. It's kind of a joint shared. Some of it's funded from the federal government, some of it's from the states. And you have to be in a qualified group, age blind or disabled, SSI, protected adult disabled children, or medically needy. Now, because of expanded Medicaid, that's not necessarily true. Now you just have to be low income since 2 years ago when Virginia did expanded Medicaid. So this is kind of the old rules, but besides expanded Medicaid, these are the rules. If you're disabled, they use the same disability requirements as the Social Security Administration. So if you're getting SSI or Social Security disability income, then you would meet the disabled group requirement. And now you don't have to meet if you're getting, you don't have to have income less than the federal poverty level anymore to get Medicaid because of the expanded Medicaid, but most of our children would. So SSI, you get Medicaid. And then you can be medically needy. I'm not going to go through all that. But Medicaid covers outpatient, inpatient, home services, physician services, and for our elderly folks and long-term care. And that's where the waivers come from, because if you are eligible to get long-term care, they have waiver programs, and we'll talk about them in a minute. So waivers. Now, waivers are a program that is paid for by the Medicaid program that waives the requirement of institutionalization. That means that somebody needs institutionalization, but you waive that requirement because we want them to be somewhere else, and that would be in the community or community-based services. So waivers provides services in the home or community rather than in a nursing home. And the income is limited to that, resources are that, and unfortunately in Virginia and many other states, the waiver funding is limited and there's long waiting lists. So I would urge you to get on the waiting list as soon as possible. And you'll do that through the Community Service Board. You don't do that at the Department of Social Services, you do that at your Community Service Board. So the New River Valley Community Service Board. And these serve people with a disability who have often with an intellectual disability, developmental disability waivers, intellectual disability or autism, and they cover all these different areas.
Ian, I have a question.
Yeah.
We are still in the process of finalizing SSI. Can I go ahead to apply for Medicaid, or shall I wait until the first SSI check will be issued?
I think you could apply. I mean, what would be the harm? But it'll be automatic once you get the SSI, you know, because they're going to look for, because when you apply for Medicaid, they have to have a disability determination if your child's 18 or, you know, younger or whatever, but they have to have a disability determination, and they will rely on the Social Security determination of that. So you don't have to wait for the check, but you have to wait for the determination. And if you apply through Medicaid, and you don't have a Social Security disability determination, it often takes a little longer to get that, because they'll give you, I think it's like 45 days for them to act on a Medicaid application. And I think they're given 90 days if they don't have a disability determination to get through the processes of the Social Security disability determination. So I hope that answers your question.
They
Okay.
said we have a disability determination done.
Yeah, so I think you could apply for Medicaid. Why not?
Okay.
Go to the Department of Social Services and say we have that. And as long as he's make sure they have under $2,000, right? Don't have more income than they would require, and they're over 18, so they don't look at your income or your resources for eligibility purposes. So, DD waivers. Now, for most of you probably know this, over, I can't remember, it's 3 or 4 years ago, they used to have ID waivers and DD waivers. Now they're all one big waiver, DD waivers. And there are different levels of support. There's the community living waiver, which I kind of look at as the golden ticket, the Willy Wonka golden ticket, because it provides pretty much everything. And then there's a family support waiver. So somebody who's maybe living at home and they don't need 24/7 care because of that. So they don't pay for as many benefits, but they do provide for a lot. And then there's the independent living waiver, somebody who could live in an apartment, who needs somebody checking in on them, maybe needs somebody to help them write his checks or things like that. So there are different categories of them, but these are the areas of that we provide services for. And then there's a long waiting list. And the one is, priority 1 is people who need it within the year. And then priority 2 and priority 3. So the thing is, they have to meet the basically nursing home level of care criteria, and they require, well, when you're on the waiting list, you're obviously not requiring services within 30 days, but you have to have a DD, a developmental disability diagnosis. And to get the community services under the waiver, it enables the individual to avoid being placed in a nursing home. So the community living waiver was previously known as the ID waiver. And that provides money for sponsored residential care or group homes. And generally, they are with someone who has a more severe disability, who really couldn't work or live independently. And then building independence is actually should be on the end, but that's known as the day support, and they can get people who are primarily independent. And then family and support is individual and family developmental disability support waiver. These were known, the former names of them, and it can give a few hours a day to most of the day, depending on what the family would need. But it's not going to be 24/7 residential care like the community living waiver. And then there's the CC plus waiver. So while you're on the waiting list, if you are in danger of being institutionalized, your family can't take care of you, that's what you have to kind of say. You could get some hours of community plus waiver benefits to provide in-home care with those with significant medical needs. And, you know, although I've had a number of families who've had some hard times getting that, because they basically have to say, well, I can't care for them without getting this, and they're going to be, you know, homeless without this. And the families have a hard time saying that, but they have to basically say, we can't do this. I'm working full time. There's no way that we can care for them. So we'd have to have them institutionalized if we don't care for them. You have to meet Medicaid income and resource limits. You have to need nursing home level of care. And that's where a lot of my clients their kids don't meet that. And they're at risk for nursing home placement, basically saying we can't take care of them. They'll have to go to a nursing home. And then these are the waiver services that are service facilitation, private duty nursing, all that. And then another public benefit, but it's an insurance program, is Medicare. And Kathy was talking about that after 2 years of getting childhood disability benefits, children will get Medicare, which is an insurance-based program. It's not needs-based, it's not income or resource-based. And many of my clients receive both Medicaid and Medicare. So let's see that. So if you want to think about benefits, you think about needs-based benefits would be SSI and then Medicaid. And then entitlement, which I think of insurance, is you think of CDB and Medicare. And I think about it this way. If Bill Gates got disabled, right? And let's say he's under 65 because he's over 65 now, but let's say he's under 65. He would get disability payments, not childhood disability payments, but he would get disability payments. And he'd also, after 2 years, he'd be entitled to Medicare, right? Well, he will never get Medicaid and he'll never get SSI because those are needs-based benefits. So just so you can think about them that way. Okay, and then there's plenty of other benefits like IEPs. I'm not going to go over all this. Publicly financed education. I think you already know your children can stay in school till age 22. They're required to have IEPs. I will say one thing, and I have a friend who is an attorney who does this kind of work, and she says that she wishes that she had gotten advocates for her children, for her child much earlier. She thought, well, I'm an attorney, I do this kind of work. And she said, I had no idea the benefits that my child could have had I properly advocated for them. So there are, number of different people who do advocate for people. Some are going to be paid, some will be volunteers. But I would encourage parents to do that because, and I know you don't go into to become a special education teacher or a teacher at all if you don't love kids and you want to help them. But I'm going to tell you, there's pressures to bear because of the financial situation of our schools that makes them not give your child literally everything they're entitled to. And unless you're a squeaky wheel, you just won't get it. So I'm not going to go over what's publicly financed. And then there's military benefits. And I'm going to go over this kind of quickly because I want to leave some time for other questions. And civil service benefits for some of you, and housing benefits, you used to call it Section 8 housing, but housing vouchers and things. And SNAP food stamps are also a benefit. And you have to have disability, limited income, limited resources. And if you're on SSI, you're categorically eligible for SNAP. And then these are the income limits based on your household size. And you can't see that, but if you get the PowerPoint, you can get that. Now, there are Medicaid buy-in plans, and basically that I look at that as expanded Medicaid. And there are special groups, though, designed for disabled individuals who are employed, which is in addition to the expanded Medicaid. And there you go. Here's the Medicaid buy-in. If your income is less than $1,400 and you're currently employed, you're a Virginia resident, and you have a WIN account. And WIN accounts are ways you can set money aside that will not affect your Medicaid eligibility. And then for Social Security, there's a ticket to work program and work incentive programs. But you have to work with somebody who knows how to key that into the system, so you don't kick yourself off Medicaid or SSI. And the plan to achieve self-support, a PASS program. Again, some of these are kind of complicated. You really need a social worker or somebody to help you do these, because I don't think they're easy to figure out. And then, of course, DARS has the vocational rehab and to do training and things like that. So that's another public benefit that's available. All right, so I'm going to stop right here. And I know there's 8 minutes left, and I want to see if there's questions. And then tomorrow night, we're going to talk about the planning that the parents can make, special needs trust. We'll talk about ABLE accounts and what you do if your child inherited something that did not go through a trust, or they have a personal injury settlement, or they've got a big something that you need to protect so that you can get them back on public benefits. So we'll talk about all that tomorrow night.
So we Mariko had a couple comments, and so going back, she said there is an age factor too for waiver priority. She said younger than 27. So thinking back about I think the Medicaid waiver eligibility. And then she had a question: how does one get qualified for both Medicaid and Medicare?
Okay, so Medicare is a insurance-based program. So you don't get it unless you've worked, like for instance, if I became disabled, I would, after 2 years, I would get Medicare because I paid into the system, and then I'm disabled and I get it. If I had a disabled child, my disabled child would get it if they were a dependent of mine and they were disabled, and after 2 years they would get Medicare, but they'd have to be disabled before they were age 22. So there's categories where you can get Medicare. If you don't fit into those categories, meaning you don't have a parent who's disabled, you haven't worked enough to get it, you don't get Medicare, you just get Medicaid. Medicaid's a needs-based program. Medicare is an insurance-based program. Hope that answers your question.
Yeah.
And many people get both. Many people end up with both, Medicare and Medicaid.
Okay. And then SSI categorical qualification for SNAP is tricky unless SSI recipient is living alone.
Yes, that's true. Yeah, because they have family limits of income for the family. That's right. That's true. I mean, most of my clients don't get I mean, most of my clients who have children at home who have SSI are not getting food stamps. No. But if they're living in an apartment by themselves, they would.
And then do you have a link for PASS, PASS?
I don't, but I could see if I could find one.
I'm blanking. What did PASS stand for?
Program, hold it. Let's go back. Let's see. Plan to achieve self-support. Plan to achieve self-support.
Huh. I wonder if that's something through DARS they help you with.
I
No,
think
it's
Social
a
Security. It's a Social
SSA.
Security plan.
Okay.
I don't know if I mean, you would think that they would. The problem is there's all these little quirky programs. There's another one and it has a number in it. I can't think of it right now, but it's another work-based plan. And there's just still like, why don't they just have one, but there's like 5, and yeah, the ticket to work and the plan to achieve self-support. And then there's this other one that's a number, and I'm sorry, I can't think of it right now.
Mariko found it and she sent it out. I'll
Thank you.
copy it and send it out for everybody too. And then we had another question. What is the range of cost for parents to budget ahead of time for guardianships cost?
Okay, so generally it's going to be a couple $1,000s, but let me tell you of this wonderful gentleman, and I'm looking it up on my phone as we speak. Where is it? Council. Okay. All right. Generally at least a couple $1,000s. And if the petitioning attorney files something called a affidavit of indigency, then the guardian ad litem, who's also an attorney, who also has to get paid, will be paid for by the state of Virginia. Okay, if you don't do that, then the petitioning attorney, the parents will have to pay that fee too. So then you're talking $4,000 or $5,000 instead of just a couple thousand. So if somebody knows what they're doing, it should just be a couple $1,000s. But let me tell you about this man. And his name is Matt Bellinger, and he is an attorney in Richmond. He runs Benny Counsel, BENECOUNSEL. You can find him on the internet, Matt Bellinger. He has a child with a disability, and he has flat fees for basically everything, for guardianship or other. I think for guardianship, as long as it doesn't involve money, so it's pretty straightforward, it's $1,000, which you cannot do. And I worked with him. I was the guardian ad litem for a case that he did, and he did an excellent job. He's great. Now you can imagine, and he does them all over the state. I don't know how he does it. I really don't, but he's an excellent resource, and I think he's an excellent attorney. So that would be a person. Now you might have to wait a while, get on his waiting list, but I think he does a great job. And so, and you can go on his website, and he does all sorts of things for people with disabilities. So, so generally a couple $1,000. Other questions?
All right, I was like Googling Matt Bellinger, and you said Benny Counsel, BENIE?
No, BENECOUNSEL.
Okay.
Did you find it?
I wanted to get back to the Zoom screen so I could see the questions, but I'm gonna one more. What age should you start the process for guardianship?
That's a great question. The earliest you could do it, earliest you can file is 17 and a half. And then, you can get it, before they're 18. I've done people's when they were 40. It depends. I mean, I think you want to consider other options, least restrictive alternatives, think about supported decision-making, think about powers of attorney. So it should be the option of last resort, not the option of first resort. Now, some people, it's obvious, we've had, and even nonverbal people, it's not that your nonverbal makes it, you need a guardian. It's just that they intellectually can't speak because they can't form the words. They don't understand. They can't do that. Somebody's like that, and they've got a significant intellectual disability. They need a guardian, because otherwise, who's going to make decisions for them, because they cannot understand to make the decisions themselves. So it depends. I don't think there's a hurry to do it, although the schools are pretty good about saying, they're supposed to, in middle school, be starting to talk about all of these issues, and I think it's all over the board about whether they are good at that or not. I think the New River Valley actually is very good at it. My understanding is, I might be wrong.
Thank you. Yeah, that's what I've heard too. I don't see any other questions. Do you guys have any other questions? Oh, well, that's good. All right, so Ann will send me these slides and we'll send it out
Yep.
with a copy of the recording
Yep.
and an email to all of you all tomorrow, hopefully,
Yeah,
or the
and
next day.
yeah, listen, give me a little bit of time because I'm going to work on this on Friday. There's some things I want to maybe expand upon or remove because I think some things could be confusing. So I want to look at it again before we send it out because I wasn't expecting to send it out. So I'd be glad to do that, but I just want to look at that and I can do that on Friday if that's okay.
Yeah, that's great. Thank you, Ann. Yes.
Uh-huh.
And yes, I will add all the links and PDFs and everything that we've talked about. It should all be in there. And so look for that maybe next week. But we'll get that out. And then but don't miss tomorrow. We're going to have a really good conversation about all things estate planning and trust administration and special needs planning. And I'm looking forward to learning more about it. So thank you, Ann. So grateful for you.
Oh, I'm glad to be here. And thank you for all your good questions. Excellent and excellent information that you shared with me. You know, it's a learning curve for all of us.
And everyone is sending their thanks to you, Ann. So thank you. And thank you, Kathy.
Yes, thank you, Kathy, for being willing to do that.
Happy to help.
All right, you all have a good rest of your evening. And thank you for coming tonight. And I'll see you tomorrow, Ann.